All right, and the court will take judicial notice of the prior testimony, of course, with the defense's objections as well
Yes,
from the
Your Honor.
prior testimony.
And all the exhibits as well.
Yes.
Right, then the state would also offer State's Exhibit A into evidence pending any objection from defense counsel pursuant to Rule 902.
I object on lack of proper foundation.
State of Texas versus Dominique Nicholson. Do I have parties announced for the record for the state?
Ashley Jones.
Your Honor.
Ryan Ephraim for Mr. Nicholson.
And are you Mr. Nicholson?
Yes, ma'am.
All right, you had a jury trial. Found you guilty of count 1 of aggravated assault with a deadly weapon.
Yes, ma'am.
And they found you guilty of count 2 of unlawful possession of a firearm as charged in count 2. And you elected to come to the court for punishment. Are both parties ready to proceed with this phase of the trial, state
Yes, Your Honor.
defense?
Yes.
All right, state, if you would read out the enhancements.
For count 1, before the commission of the alleged offense in cause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996 and cause number 94 CR 5960 in the 187th District Court in Bexar County, Texas, the defendant was convicted of the felony of aggravated robbery with a deadly weapon, the ZID gun. And before the commission of the primary offense and after the conviction in cause number 94 CR 5960 was final, the defendant committed the felony of assault, family violence, and hand.
Welcome to one of the most intense sentencing hearings you'll see. State of Texas versus Dominique Nicholson. A man with a criminal past stretching back decades, now facing the consequences of a violent confrontation involving a firearm. 2 charges: aggravated assault with a deadly weapon and unlawful possession of a firearm. But here's the twist. His defense leans heavily on a troubled childhood and time served from the age of 16. This courtroom session is packed with raw emotion, sharp legal arguments, and a final judgment that might surprise you. Was justice served? Or was the system too late to save a man beaten down by life? Let's break it down.
And was convicted on the 29th day of January 2013 in cause number D-1-DC-12-904040 in the 427th District Court in Travis County, Texas. For count 2, the state is alleging that the defendant is a repeat offender, and so before the commission of the offense alleged in cause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996 in cause number 94 CR 5960 in the 187th District Court in Bexar County, Texas. The defendant was convicted of the felony of aggravated robbery, deadly weapon, the ZID gun.
All right. With regards to the enhancements in count 1, both enhancements, how do you plead? True or not true?
Not true.
And with regards to the enhancements as read for count 2, how do you plead?
Not true.
All right. Are there any opening statements from either side?
No, with the state will waive opening.
Waive opening.
All right, state, you may call your first witness.
Preliminarily, the state, that, Your Honor, the state would like to offer and admit all testimony and evidence that was heard in the guilt innocence phase of trial.
I believe the judge can take judicial notice of those things.
All right, and the court will take judicial notice of the prior testimony, of course, with the defense's objections as well
Yes,
from the
Your Honor.
prior testimony.
And all the exhibits as well.
Yes.
Right, then the state would also offer.
And just like that, both sides are ready to proceed with the punishment phase. This moment is huge. The guilt phase is over. The jury has done its job. Now it's the judge's call. Will Nicholson's past come back to haunt him? The state's about to lay down a timeline of violence that started nearly 3 decades ago. Buckle in.
Offer State's Exhibit A into evidence pending any objection from defense counsel pursuant to Rule 902.
I object on lack of proper foundation and link to defendant and hearsay.
All right, the objections as it relates to hearsay, those will be overruled. It appears to the court that State's Exhibit A is a self-authenticating document. However, with regards to whether or not this is connected to this defendant, then that objection will be sustained.
And Your Honor, if the state could respond, the state would respond that that goes to weight, not necessarily admissibility. It is a self-authenticating document.
No, I'm overruling her objection as far as that this document is not what it purports to be. It is self-authenticating. But what the part of her objection that I'm sustaining is that State's Exhibit A has not been tied to this defendant.
Well, yes, Your Honor, I understand that.
So foundation will have to be laid to somehow tie this document to this defendant. All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Mia Valdez.
All right, state.
Ms. Valdez, could you please tell the court what your area of expertise is?
I'm a fingerprint examiner for the Bexar County Sheriff's Office.
And do you have any, do you possess any certification?
Yes, I have a certification in classifying fingerprints as well as identification of fingerprints.
Please explain what those include.
So we go through a rigorous course to understand the characteristics of fingerprints as well as on-site training to understand fingerprints.
Let's talk about fingerprints specifically. What is it?
A fingerprint is a print that consists of 12 characteristics that can identify an individual.
Have you ever found two different people to have the
Now here's where things get serious. The prosecution isn't just trying to punish Nicholson for this one case. They're stacking his past convictions like dominoes. 1996 aggravated robbery, then a 2013 assault case. The goal? Show a pattern, establish that this isn't a one-off mistake, this is a man, they argue, who's had multiple chances to walk the straight path, and chose not to. But are they building a fair case, or burying a man with history?
same set of fingerprints?
No, not to my knowledge.
Can you please explain how you do a fingerprint comparison?
So when we first get the fingerprints, we do look for, like I said, the 12 ridge counts. And we will compare to see if the individual that we do have in custody is the same person that is on the fingerprint itself. And then we do our Henry classification that classifies the specific characteristics of the fingerprint.
Now, if that is your way of doing it, is that the standard way?
That's the standard.
That's the what way?
The standard.
Can you take the witness on board diary?
Yes.
I may be a little confused. This exhibit B, when were those prints taken?
These were taken today.
And so when you were saying that those prints were taken by me, is that the one you were referring to?
Correct.
Okay. And so there's some other prints in the packet, right?
Correct. They're on the back of it.
Okay. But you were not saying you took those.
No, I didn't.
Okay. So you don't know my client, right?
No.
So you can say that the prints match, and you can say that you took the prints of my client today, correct?
Correct.
But you weren't present when the prints were taken originally, right?
No, ma'am.
And so you can't say you didn't witness that, or who the person was who gave the prints.
Correct.
I would object to relevance and lack of affirmative link to my client.
All right. And so is the testimony,
I'm sorry.
was it established who these prints and State's Exhibit B were taken from?
I'm sorry, Judge?
Was it established who the prints were taken from in State's Exhibit B?
Yes.
She did testify to me with her, she talking about that individual today.
What individual?
Watch this moment closely. The defense challenges the fingerprint records. Why?
Because the person testifying took only today's prints, not the ones from past convictions.
That's a strategic objection. If they can't directly tie the old convictions to Nicholson, it weakens the enhancement claims. Smart move, but will it stick? Spoiler, it doesn't. The judge overrules most objections, but does acknowledge a technical gap.
You want to, yes.
Ms. Valdez, you testified that you took the fingerprint stakes at the beat today, correct?
Correct.
You see the person in the photo that you took those fingerprints from?
Yes, sir.
Could you please point to that person, identify him by an article of photos?
Will be the gentleman in the red.
You represent the record reflect that witnesses identified the person that you took the fingerprints from, as Exhibit B.
All right. Defense, any objection with regards to States Exhibit A and B?
I reurge the same objections, Your Honor. She has no knowledge of the person who gave the original prints.
All right, those objections will be overruled. States Exhibit A and B are admitted over defense counsel's objection. State, any other witnesses?
No, Your Honor, the state will rest.
Defense, any witnesses?
No, Your Honor.
Defense, do you rest?
Yes,
State, do you close?
Yes, Your Honor.
Defense, do you close?
yes.
All right. As previously stated, the court is finding the enhancements true. And the court is finding the enhancements true that were read into the record for count 1, and also the enhancements true that were read into the record for count 2. The court will hear argument with regards to sentencing. Mr. Nicholson, you are not eligible for probation from the court. All right.
Yes, Your Honor. The state would like the court to consider States Exhibits 39 and 40, which was entered in the guilt phase of trial. That's going to be the judgment from Austin for the conviction of assault enhanced. And additionally, the fingerprint part that was linked to that judgment in the guilt phase of trial. Your Honor, this defendant.
This is rare and important. The judge sustains part of the objection. She acknowledges that while the documents are valid, they haven't yet been tied directly to this defendant. That's a win for the defense, briefly. But the state's ready with fingerprint testimony to make that connection airtight. If they succeed, those enhancements stay on the table.
Does have a very lengthy and violent criminal history. In 1996, he was sentenced to 20 years for aggravated robbery. That's going to be cause number ending in 60 that we entered in today. He was additionally sentenced for burglary of a habitation on that same day. That's going to be cause number ending in 59 that was entered into evidence today as part of States Exhibit B. States Exhibit A. Your Honor, he was sentenced in 1996 to 20 years in the Texas Department of Corrections for those crimes. When he was released, it was not very much longer until 2013 that he committed the offense in States Exhibit 39 for assault enhanced, where he was convicted and sentenced to 6 years. So in 2019, after their 5 years are done, it took him only 3 years to commit this offense, this violent offense, where he shot at an unarmed Uber driver who just happened to be picking up his stepdaughter so that she could go to work. Thankfully, nobody was hurt in this offense, but that's just luck, Your Honor. The capacity for this defendant to hurt people in this community and to hurt his family is shown by the criminal history, and the state is asking that the court sentence the defendant.
Boom. This moment is the nail in the coffin. The fingerprint examiner identifies Dominique Nicholson in court as the man she took prints from today and confirms they match the older records. That's the link the state needed. The defense objects again, but it's game over for that argument. The judge admits Exhibits A and B. Enhancements are now fully in play.
To no less than 40 years on count 1 and no less than 20 years on count 2.
Defense?
Thank you, Judge. I know that we've heard about his criminal history and the seriousness of it. I did want to offer some context to that, which starts with the fact that the first offense that for which he did the 20 years, he was actually age 16 when that happened. And he was certified as an adult and sentenced, and he ended up doing most of the time. He really lost so many of his formative years at doing that time, right? And then he gets released and is having trouble and has continued to have trouble adjusting. And, the second case, the family violence assault case, he pled to, and he acknowledges, and I'm not saying he doesn't acknowledge the first case, but he does ask, and we do ask the judge to consider how young he was at that time. I have had contact with two of his family members, siblings, who are not able to be here today. One was a Mr. Paxton, and another is a sister, Samantha Romborg. And if I'm
Here comes the heat. The prosecutor paints a harsh picture. Nicholson, as a career criminal, a man who's never changed despite multiple convictions. She emphasizes the violent nature of his offenses, especially the recent shooting at an unarmed Uber driver. Her closing argument? No less than 40 years for count 1 and 20 for count 2. That's not just punishment, it's a statement to the community.
they both relate to me the chaotic and troubled childhood that they had, and how, in spite of what you see here today, that Mr. Nicholson was actually a loving and caring brother.
I'm sorry, do you want those witnesses here?
No, I think we discuss it.
No objections from the state.
Okay.
That their father was a drug addict, and all the children in the family suffered tremendously, and that Dominic felt an enormous responsibility to try to provide for his siblings, which led him to make very poor choices to accomplish that goal, but that his actual motivation, and led him down a criminal path, which I guess partly was role modeled by his father, but also his sense of duty and obligation to his siblings, and having very limited ability and resources to provide for them in his overwhelming sense.
Now the emotional turn. The defense brings in the backstory. Nicholson was just 16 when he got that 20-year sentence, a childhood marked by chaos, poverty, and drug abuse. His attorney argues that Dominique didn't stand a chance from the beginning, and that, despite his mistakes, he's not beyond redemption. It's a powerful contrast. Cold facts versus lived trauma. Does it sway the judge?
That he should try to provide for them really hindered his thinking, and obviously has made extremely poor judgments. I know we stand here today, the jury heard the evidence and returned their verdict, but Mr. Nicholson believes that he can return to society and be rehabilitated. This has been a long revolving door in his life that he is very tired of. And so we would ask the court to please sentence him at the minimum range.
All right. State any final closing argument?
Your Honor, the state does appreciate that Mr. Nicholson was young when he committed the first offenses. However, I think that just speaks to his personality as prior life. And although the hopes for change are there, according to defense counsel, his actions speak louder than his words. And the court would like, the state would like the court to consider those actions, the harm that he could have caused on October 25th, 2022, and the harm that he has caused throughout his life.
This is the most powerful part of the hearing. The judge steps out of her robe and speaks like a human being. She acknowledges the cycle of trauma, the weight of a brutal childhood, and how some people never recover. But she also lays out a universal truth. Pain doesn't give you license to pass it on. It's a fair but sobering moment, a rare balance of empathy and accountability.
All right. Is there anything you would like to say?
Yes, ma'am.
Here's the thing. If you want to say something, I'll take you under oath and the state will be allowed to question you. I mean, if you want to discuss it more with your attorney,
My life to be over like this. not being able to say it, but I won't say.
No, I mean, we can go off the record. Here's the thing. Once you decide to testify, and I think your defense counsel will tell you, there are certain appellate issues that may or may not be waived. So it's completely up to you. If you want me to hear what you have to say, I will hear it. What I can tell you with regards to my clients, sometimes they will want to speak, and I would tell them, your family has already told your story. Are you going to say something different than what your family has said? So the state was very generous in allowing your counsel to make a proffer to the court about your childhood.
I understand.
So, but if you would like to say something, it's only fair, because I want to be fair to both sides. You don't get to just say something and then that's it. What will end up happening is I will swear you in, you'll be under oath. And if you just want to speak generally to me, you can speak generally. I'm not going to sustain any objections for narrative, because sometimes people just want to tell me what their thoughts are and I will listen to them. But that being said, whatever your thoughts are that you want to make sure that I know about, then the state will be allowed to cross-examine. So if that
And there it is. The judgment: 30 years for aggravated assault, 20 for illegal firearm possession, served concurrently. That's a heavy sentence, but it stops short of life. The judge even says outright, "You're not a good candidate for probation, but I also don't think you should spend the rest of your life in prison." It's a rare blend of firm justice and withheld finality. There's still a door, just barely, left open.
that's what you want to do, then we can do that.
I've seen it. I hope. Thank you.
All right.
I guess I would say, I know he feels like he's really in the fight for his life here. And,
No, we're not on the record yet. No,
okay.
we're still off the record. Yeah. All right. So y'all ready to proceed? Mhm. All right. We're back on the record. All right. Mr. Nicholson, this is what I want you to know. No matter what offenses people are alleged to have been committed in this court, it could be offenses that people think are the worst of the worst. I still see everybody as a human being. And when I look at them, many a times I see them when they first start school, like first grade. And I always wonder what made this one child turn left instead of going right. Some people have horrible childhoods and they turn out great. They have a horrible childhood and their thing is, I'm not going to be this way. I'm going to be on the straight and narrow because I need to do this and that. Some people can't overcome it. You know, life just beats them down. And sometimes when you watch movies, when we were growing up, we would watch movies and you see these two children and you thinking everything's going to turn out great for them. And there's one pivotal traumatic thing that happens in their life and it gets them off track and they're never able to get it back in. For example, with you, you went to prison, right? People will go to prison and when they get out of prison, they say they're going to do great things. They're not going to get in trouble anymore. They're going to walk the fine line, right? You get out, you say, I'm rehabilitated, and you say, I'm going to get a job. And then when you try to get a job, people look at your history and they say they're not going to give you a job. And so that's one way where society beats you down. And then you keep trying and you keep trying. And then maybe there's a friend who comes along or somebody who comes along and said, hey, here's some easy money. And maybe you have siblings that you're trying to take care of, trying to make sure they don't have to go through what you went through. But at the end of the day, we all got to pay for our offenses, right? Now, do I think that you should get life in prison? No, right? Your minimum is 25 on the first on count one. It's from 25 up to life in prison and up to a $10,000 fine. All right. This is what the court is going to do. The court is taking in consideration the state's argument about his history, because I have to consider that. But then I'm also taking into consideration what the defense said. And I think everybody would agree for someone to be 16 and to end up being sentenced to 20 years in prison. And I'm assuming He did the 16 when he was at juvenile, but once he became an adult, they sent him to prison with adults. So for a child to end up in prison with adults who have all of their issues, I'm sure they looked at him a certain kind of way. But even though that happens, we can't be in a situation where life has beat us down, so therefore we're going to beat other people down, because then it just becomes a circle. So all of the offenses that you've committed, guess what? That complainant has been traumatized. So there has to be punishment, and you're not eligible for probation.
What a closing moment. The judge turns mentor, not executioner. She tells Nicholson it's not over. He can still get degrees, mentor others, stay connected with family, and maybe, just maybe, find a way back. It's real, raw, and rare in a justice system known more for bars than bridges. This is accountability with a sliver of hope.
And based upon what I've heard during the trial and based upon what I've heard during this punishment phase, I would not grant you probation, right? Even if you were eligible, because I don't think you're a good candidate for probation. But I also don't think you should spend the rest of your life in prison. All right, so in count one, as previously stated, I'm finding both enhancements true. In count two, I'm finding the enhancement true. In count one, I'm going to sentence you to 30 years in the prison. In count two, I'm going to sentence you to 20 years in the prison. The counts will run concurrently. There's an affirmative finding of deadly weapon in count one, and there's to be no contact with Jayla Satterwhite. Is there anything else with regards to sentencing from state or the defense?
Taking into consideration.
All right, and the court will order affirmative finding of family violence.
And I assume then the court will be giving him credit for all time served.
Yes, and you'll receive credit for any time served that you've been in custody. And counsel, if you believe the credit is incorrect, just let the court know. We'll make sure that it's corrected. And for some reason, I do not have the trial court certification. I'm sure you probably filled it out before, but do you mind filling out another one for the court?
Okay.
Yes, it's on the wall. And she's going to give you a document that's entitled Trial Court Certification of Defendant's Rights to Appeal. You do have a right to appeal because this is a jury trial that occurred. Do you understand?
Yes, ma'am.
All right. Your counsel is court appointed. So what will end up happening if she withdraws from your case, a new attorney will be appointed to handle any appellate issues. Do you understand?
Yes.
All right. Because this is an affirmative finding of family violence, and also because these are felony convictions, and you should know by now, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. Do you have any questions about anything?
Just, I didn't hear you. I don't know if you were doing it or not. The fines.
No, fine.
Thank you.
All right. Here's your document.
Thank you.
You're welcome. We can go off the record. So, Mr. Nicholson, I know it's a lot of time, right? And you have to do half before you're eligible. But guess what? At the end of the day, it's not the end of the world for you, right? You're going to be older when you are released from prison. There's no ands, ifs, or buts about it. But you can still take this time to try to better yourself while you're at the prison. You can still get degrees. Young people who come into prison, if they're not acting crazy, you can probably give them some advice to help them do better and be better. And you're still alive. You can still pick up the phone, call people. You can still write letters to people. Hopefully people will come visit you at the prison. You can still have that. As long as we're alive and breathing, we have the opportunity to change. You understand?
Yes, ma'am.
So it can still be done. You can still come out and do great things. All right. All right. Good luck to you. We're going to see you back on Tuesday. Okay.
Okay.
All right. Thank you.
Thank you.
We're off the,
You're welcome.
off the record.
Yes.
Okay, so just a matter of logistics on the appeal.
Yes.
I'd file a motion for new trial and then wait to file the motion to it, because I'm not on the appellate wheel.
Well, what we can do is we can take that up on Tuesday
Okay.
because you'll still have enough time. 30
Okay.
days will not have
Right.
expired.
I just want to make sure I get it in the right order?
Yes.
Because I think there was a particular order on the motion to withdraw on the file.
Yes.
Okay,
All right, thank you. We'll see you back on Tuesday.
okay, thank you, Jen.
Thank you.
So there you have it, Dominique Nicholson. Sentenced to 30 years for aggravated assault with a deadly weapon and 20 years for illegal firearm possession. The judge acknowledged his trauma, his youth at the time of his first conviction, and the brutal cycle that shaped him. But in the end, history, violence, and public safety weighed heavier than empathy. If you found this case as shocking, emotional, and thought-provoking as we did, make sure to like this video, drop your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay sharp, stay informed.